Good afternoon, everyone, and good afternoon to everyone on the webinar. Thank you for coming, and we'll jump right into it. The first case that we have for you is an ADA case. Oh, there we are. It's titled Tina Bauman v. Walt Disney World Company. In this case, the plaintiff suffered from a disorder called limb-girdle muscular dystrophy. This made it difficult for her to walk or stand up from a seated position. Well, when she tried to attend Disneyland, she asked for the use of her Segway, which is a two-wheeled vehicle that you stand up on and kind of zip around. Well, Disneyland denied that request, saying that they do not allow two-wheeled motorized vehicles, but they do allow wheelchairs and scooters. Well, in response to that, the plaintiff decided to sue, and she was claiming that Disneyland had denied her full and equal access to the park. Well, in response to that, Disney filed a motion for summary judgment, stating that the plaintiff was judicially stopped from claiming that she couldn't use a wheelchair because she had done so in 3 prior lawsuits where she had claimed that she needed the use of a wheelchair for the various places where she was trying to get into there. The court granted that motion for summary judgment, and the plaintiff appealed to the Ninth Circuit. The circuit first addressed the judicial estoppel argument and agreed with the district court that the plaintiff cannot flip-flop her views now and say that she can't use a wheelchair when she had done so in 3 prior instances. And the reason for that makes sense, is that we want to maintain judicial integrity of the judicial process. And the court next moved to the exact ADA issues that she had brought up. The ADA prohibits discrimination on the basis of disability and the full and equal enjoyment of goods, services, facilities, privilege, advantages, accommodations, and of any public place. Discrimination is the failure to make reasonable modifications in policies, practices, or procedures when the modifications are necessary to afford such goods, services, and use of the facilities. Disneyland was arguing that it wasn't necessary that she use a Segway to use Disneyland. She could use a wheelchair. Well, the court analyzed that argument and stated that when looking at an ADA analysis, the facility owner needs to consider how a non-disabled person uses their facilities and what are the reasonable steps that can be taken to make the accommodations accessible for the disabled person to get a like experience. And here, the court noted a study done by the DOJ, which enforces the ADA, that stated Segways are likely, that facility owners will likely need to allow the use of Segways unless they can prove that a Segway can't be used safely on the premises. Here, the court decided to remand this case back down to the district court to allow Disney the opportunity, if it could prove so, with facts and evidence, that a Segway can't be used safely in its parks. And it possibly could do that. Traffic, it could be too condensed with how many people are in there, and the Segway goes too fast. So it's possible, but the court wasn't satisfied with the vague opinion of Disney that it was unsafe. So the case is important in that our clients and our insureds need to occasionally update their policies that reflect the ADA to take into account these new developing technologies. Because if they don't and they kind of apply these old policies, they may actually be exposing themselves to liability in the ADA. All right. We're going to move to the anti-SLAPP statute here in California. This case is Jmenez v. Encennial School Parent Teachers Association. This involves a 4th grade teacher or coach of a basketball team who was having issues with one particular student who was throwing basketballs at other kids and throwing basketballs at the lights and just being very disruptive. He communicated that to the leadership of the league, and the league initially ignored him, and then actually was telling him that he was discriminating against this particular child and that his coaching style was getting aggressive and out of order. And they communicated these issues to the PTO organization and also to the parents of the various players. And then at the end of the season, they decided that that coach was no longer going to be allowed to come back, and he would no longer be able to participate in coaching in the league. Well, in response, the plaintiff decided to sue. And he, representing himself, filed a 20-page complaint, including 8 causes of action. Not surprisingly, he is a lawyer by profession. But maybe this isn't so good. In his complaint, he seemed to be alleging libel and slander, but didn't properly plead it. The plaintiff moved, pursuant to Civil Code Code of Procedure Section 425.16, the anti-SLAPP statute, to eliminate the case at an early stage. For those not familiar with this statute, an anti-SLAPP is a special motion to strike when an action against a person arises from any act in furtherance of the person's constitutional right of petition or free speech in connection with a public issue. And then the court must analyze if the plaintiff has established a probability of success on their claim. Well, at the district court level, the court gave the plaintiff the benefit of the doubt and said, well, though you haven't pled defamation properly in this case, it sounds in defamation, and we think that defamation is not within the purview of anti-SLAPP. Well, of course, the defendants appealed, and at the appellate court, the first issue that they addressed was whether defamation is within the scope of an anti-SLAPP statute, and the court held, of course it is. That's basically one of the biggest causes of action that anti-SLAPP is used to eliminate. Next, it moved to whether the issues involved in the case were those of a public issue, and the court held, of course, the relationships between coaches and players and the teachers is a public issue that's very prevalent through many of us that have kids and put our kids through these leagues. So yes, this involved a public issue. Now the court needed to see, did the plaintiff actually present facts that would create a probability of success on the claim? And the court said no. The plaintiff failed to even prove or provide evidence of the first element of a defamation claim, which is a statement about the plaintiff. He didn't identify any statements that were said to anyone. The court even went one step further and tried to take the totality of the circumstances in the complaint and said, well, any statements that may or may not have been said were said amongst interested parties done without malice, which constitutes a privileged communication pursuant to Civil Code Section 47. So some interesting issues here that, number one, defamation is within an anti-SLAPP statute, and we can use that to attack that cause of action at an early stage versus having to go throughout the long, costly litigation process. And secondly, to evaluate when there's a defamation claim, what's the relationships between the two people, what the person's saying the statement and to whom it is said, because it may be privileged if it falls into this interested persons category. All right. Next, we're going to move on to arbitration in Kyle Pulley versus Pony International. Here, this involved the plaintiff was a designer of shoes. He was recruited by Pony International to come and design shoes for them in San Diego. He was offered compensation along with a 0.75 ownership interest. Once he gets down to San Diego, a couple months later, Pony approaches him with a new employment agreement. And in the agreement, there's an arbitration provision. And they say, well, you need to sign this new employment agreement or we're not going to give you that 0.75 ownership interest, which had already started to vest. Well, the plaintiff capitulated, signed the contract, and about 18 months later, of course, was terminated. And being terminated, he sued. And so in the suit, he alleged fraud, wrongful termination, and a bunch of other causes of action. At that point, Pony made a motion to compel arbitration. And of course, the plaintiff opposed that motion to compel based on Labor Code Section 206.5, which and that section prohibits an employer from requiring an employee to execute a release of a claim on a right of an account of wages due. And the plaintiff was saying, hey, you can't make me waive my right to a jury trial and hold my wages as kind of as a threat. And Pony filed a reply addressing whether 206.5 applied to the case at bar. The trial court agreed with the plaintiff and said that 206.5 voided the arbitration provision, and the defendant appealed. Pony tried to first address that this whole issue should have never been decided by the trial court and should have been arbitrated. Well, the appellate court said, no, you waived your right to have the 206.5 applicability issue arbitrated when you decided to address the merits of 206.5 in your reply to the opposition. So very quickly, that issue in terms of being able to get it to an arbitrator versus a trial court was waived. Now, next, the court addressed 206.5 itself and the merits. Does it apply to waivers of jury trial rights? And the court said, no, it does not. 206.5 is concentrated on the release of a claim or right to wages, and specifically in the statutory language read with common language. And also that's supported by reading Section 206 inside the Labor Code. Generally, it's all about wage disputes. But the court was a little weary of what happened here, and in a footnote stated, although 206.5 doesn't keep employers from kind of withholding wages to get people to sign arbitration provisions, that there may be other laws out there that will keep them from doing that. So a big takeaway here is when we're decide that arbitration is the best avenue in a defense, we need to be consistent that we stick to enforcing that arbitration provision and not accidentally get lured into litigating very particular parts of the case, because we may waive our rights to have those things arbitrated when we find it in our best interest. And although 206.5 doesn't keep employers from doing what Pony did here, it's likely unadvisable for our clients or for an insured to dangle past compensation due over the heads of employees to force them into arbitration agreements.
Good afternoon, everyone. It's a pleasure to present to you today. The first case that I'm going to present involves contractor liability, and it's called Brannon versus Lathrop Construction. In this case, the plaintiff, Brian Brannon, was employed as a bricklayer for Brannon Masonry. Brannon Masonry subcontracted with the general contractor, Lathrop, to perform brickwork at the El Cerrito High School. Lathrop also subcontracted with Henley and Company to perform plastering work. Lathrop required both subcontractors to adhere to federal and state safety protocols. All parties had the authority to stop work for any safety reason. Lathrop scheduled Henley's plastering work to begin first. After the plastering was done, Henley was required to remove all of its scaffolding to allow the brickwork to begin. However, on the day of the incident, Henley left a portion of its scaffolding up. And it was raining. Plaintiff began the brickwork and slipped on Henley's scaffolding and was injured. Plaintiff sued the general contractor, Lathrop, for his injuries, alleging negligence and premises liability. Plaintiff argued that as the general contractor, Lathrop was required to remove the scaffolding before the brickwork began. Lathrop moved for summary judgment and won. The Court of Appeal affirmed. The Prevet-Tolan doctrine establishes the general rule that an employee of a subcontractor may not recover for personal injury damages against the general contractor unless that general contractor has retained control over the instrumentality causing the injury. The rationale behind this rule is that the subcontractor is in the best position to ensure the safety of its employees. In addition, the injured employee has recourse through the workers' compensation system. An exception to this general rule was developed in the Hooker versus Department of Transportation case. In this case, the Supreme Court held that a general contractor may be liable when their action of retained control over safety affirmatively contributes to the injury of an independent contractor's employee. In this case, the court found that the Hooker exception did not apply. Here, Lathrop's coordination and scheduling in allowing the scaffolding to remain up was not an affirmative action on its part that caused Brannon's injury. Lathrop, in this instance, did not direct the employee's actions on that day. And Brayton never raised a safety issue regarding removal of the scaffolding. So here we see that courts do require some type of affirmative action on behalf of a general contractor and when they look at imposing liability for injuries to subcontractor employees. Now, a case for liability might have been established in the event that evidence was set forth that the general contractor, Lathrop, had somehow violated its own safety rules, which resulted then in a subcontractor's injury.
All right, next we'll deal with another employment vicarious liability case called Taylor Patterson versus Domino's Pizza LLC. In this case, the plaintiff was a teenaged employee of a franchise. She sued the franchisee, the assistant manager, and also Domino's itself for sexual harassment and other related claims. The claims against Domino's itself were based on vicarious liability. Well, of course, Domino's moved for summary judgment, stating that the franchisee was an independent contractor, as clearly stated in the franchise agreement. And the trial court agreed. And at that point, the plaintiff appealed. The appellate court first wanted to lay out that franchisors can retain certain types of control over their franchisees. And these are very common issues such as trademarks, quality of goods, quality of services, whatever the franchise is involved in. However, a principal-agent relationship can come into existence when the control becomes substantial control. And how to evaluate what is substantial control is going to be dictated not by necessarily what's in that franchise agreement, but the nature of the relationship and the totality of the individual circumstances involved. Well, here, the Domino's area manager, according to the deposition testimony of the franchisee, had substantial control over all of his decisions in his business. And if he did not comply with what the franchise or the area manager said, he would be quickly put out of business. Additionally, in this particular case, the area manager suggested that he fire the plaintiff in this case. Other forms of control the court noted were that Domino's controlled the dress of employees, demeanor, jewelry, facial hair, trainings, and even tried to control particular conversations that occurred inside the franchise itself. All of these elements brought together created at least sufficient facts of possible substantial control to overcome summary judgment, and that a jury could reasonably conclude that substantial control between Domino's and the franchise itself existed, and that vicarious liability could be imposed. So it's a pretty important fact that we have lots of clients and lots of insureds that use independent contractors on a very regular basis, not in the franchise context, even in the contractor-subcontractor context. Well, the independent contractor designation in a contract is not going to dictate whether that is what the relationship actually is. So understanding what our client's relationship with their supposed independent contractors is very important. Same thing with understanding how they deal with their subcontractors, at least as an insured, because they could open themselves up just by the way, their micromanagement of their independent contractors will open them up for vicarious liability.
The next case is a negligence case entitled Mezcua versus Los Angeles Harley Davidson Inc. This case involves the assumption of risk doctrine. In this case, Harley Davidson sponsored an annual toy ride motorcycle parade to support a holiday toy drive. Registration required the motorcyclist to sign a release form expressly agreeing to assume the risk of any injury or accident. Robert Mezcua and his wife decided to participate in the event. However, they did not formally register for the event and did not sign a release. Mr. Mezcua was a very experienced motorcyclist and had participated in similar rides before. But while riding in this parade, a van collided with the Mezcuas and caused them injury. The Mezcuas sued Harley Davidson Inc., the organizer of the parade. Harley Davidson successfully moved for summary judgment on the theory that plaintiff's claims were barred by the assumption of risk doctrine. The appellate court affirmed the decision of the trial court. Here, the court said the assumption of risk can be either express or implied. The implied assumption of risk is based on the nature of the activity and the relationships of the parties to that activity. Here, Harley Davidson had done absolutely nothing to increase the risk that is inherent in the sport of motorcycling. The court reasoned that motorcycling is a sport that requires physical exertion and athletic risk and is comparable to an organized bicycle ride. So accordingly, the court applied the implied assumption of risk doctrine to bar plaintiffs' claims. So here we see that the courts are willing to impose assumption of risk to bar plaintiffs' claims based on the dangerous and inherent nature of a particular activity, as well as the plaintiff's relationship to that activity, even if there is no express assumption of risk. The next case is another negligence case entitled Diaz versus Carcamo. This is a recent California Supreme Court case involving vicarious liability in the context of a multi-vehicle car accident. In this case, the plaintiff, Don Diaz, was driving south on US 101 in Ventura County. Defendant Jose Carcamo was driving the other direction in the northbound center lane of the highway in a truck owned by his employer, Sugar Transport. Another defendant, Karen Tagliaferri, was driving south behind Carcamo in the center lane and attempted to pass him on the left. But after she passed Carcamo, she cut over too soon and clipped the back of her vehicle, causing her to spin out of control, go over the center divider, and run into Diaz's vehicle. Diaz sustained serious injuries and sued Tagliaferri, Carcamo, and Sugar Transport for negligent driving. Diaz alleged that Sugar Transport was vicariously liable for its employee Carcamo's negligent driving. Diaz also alleged that Sugar Transport was independently liable for negligent entrustment in hiring and retaining Carcamo. At trial, Sugar Transport offered to admit that it was vicariously liable if Carcamo was found negligent. Since it admitted vicarious liability, Sugar Transport argued that Diaz should not be allowed to pursue a separate claim for negligent entrustment. Sugar Transport relied on a California Supreme Court case, Armenta versus Churchill, in which the court held that if an employer admits vicarious liability for its employee's negligent driving, a plaintiff's claim for negligent entrustment is barred, and such that a plaintiff may not introduce evidence of that employee's negligent driving record at trial. However, over Sugar Transport's objection, the trial court admitted negative evidence of Carcamo's driving history. Some of this negative evidence included that Carcamo had been in 2 prior truck driving accidents, one of which he was found at fault. He had been fired from 3 of his 4 trucking jobs. He was an illegal resident and had falsified his social security number to get the job. After hearing this evidence, of course, the jury found that drivers Tagliaferri and Carcamo were negligent and that Sugar Transport was independently liable for negligent entrustment of Carcamo. The jury allocated fault to Tagliaferri, Sugar Transport, and Carcamo, and the plaintiff was awarded $17.5 million in economic damages and $5 million in non-economic damages. The Court of Appeal affirmed. The Supreme Court reversed, relying on its prior decision in Armenta. The court reasoned that vicarious liability and negligent entrustment are actually alternative theories. As an employer, Sugar Transport could only be held vicariously liable for the share of negligence assigned to Carcamo. Sugar Transport's admission of vicarious liability barred any separate claim for negligent entrustment. The trial court in this instance improperly admitted evidence of Carcamo's negative hiring history and driving history. Such evidence became irrelevant once Sugar Transport admitted vicarious liability for Carcamo's actions. So here we see that if an employer of a negligent driver admits vicarious liability, it can be advantageous to bar negligent entrustment claims and to prevent potentially damaging evidence regarding hiring and driving history from getting before the jury.
All right. Next, we have Howard v. Omni Hotels Management Corp. This is a good bridge. It's both a negligence case and a products liability case. The facts are pretty simple. The plaintiff was staying at an Omni hotel in San Diego, California, when she slipped on a bathtub and sustained some injuries. She sued both Omni Hotel and the manufacturer of the tub, which is Kohler. She sued the hotel for negligence and premises liability and the manufacturer for products liability. Well, after discovery, both the hotel and Kohler moved for summary judgment, claiming that the bathtub met industry standards and that based on that, there was no premises liability. That's what Omni argued, and the court initially agreed with both, granting the summary judgments, but then subsequently decided to grant a motion for new trial as against Omni itself based on two particular instances of similar slippings in Kohler bathtubs in New Haven across the country from where this happened. Appeals started from there. Plaintiff appealed the Kohler motion for summary judgment and Omni the motion for new trial. The appellate court addressed the products liability case section first. The plaintiff had a very sloppy pleading of products liability in this case, but the court focused on the defective designs test argument by the plaintiff. The defective designs test attempts to ask, does the defective product design embody excessive preventable danger? And in order to prove that, you need expert testimony, both on the plaintiff side and on the defense side. Well, in this case, both plaintiff and both defendants' experts said, yeah, these tubs met industry standards in terms of slipperiness and the concaveness, I guess, of the base of the bathtub, which are supposed to provide traction. Well, what the plaintiff was attempting to argue is that industry standards themselves are insufficient in this area. And the court said, well, under the defective designs test, plaintiff, you're right. Industry standards are not necessarily sufficient to avoid liability for the manufacturer. However, if you're going to argue that industry standards are insufficient, you have to supply evidence of that fact. And that's more than mere speculation and an opinion of your expert. That opinion needs to be based in some type of fact, testing, so on and so forth. And the plaintiff had failed to do that here. It was just merely a lot of pontificating by the plaintiff's expert that industry standards were insufficient. And so the court held as to the manufacturer that the motion for summary judgment was proper. Now moving on to Omni Hotels and the premises liability, as I'm sure we all know that commercial property owners are liable for dangerous conditions that the owner has actual or constructive knowledge of on their property. It's the plaintiff's burden to show this actual or constructive knowledge. Well, in this case, as I said before, there were only two reports of slippings in Kohler bathtubs done across the country, and the facts in the reports weren't really the same as what had happened here. So the court said that's not sufficient for Omni Hotels to have constructive knowledge of that this product, people slip and fall on it. So the takeaways here is when we're dealing with experts in a products liability context and they're trying to argue this, that our industry standards are insufficient, we really need to nail them down on make them do work, right? Make them go out and find evidence and test why the industry standards are insufficient, not just let their experts wildly opine. And secondly, for the constructive notice, when we're dealing with a client or an insured who has a large organization, it's not necessarily going to expose them to premises negligence liability if two instances of quasi-similar facts occur in some type of injury. There needs to be more to establish constructive knowledge.
The next case is a products liability case. It's entitled Maxton versus Western State Metals. In this case, the plaintiff, John Maxton, was a laborer for LaField Manufacturing for over 30 years working with metal products. He cut, grinded, and welded steel and aluminum sheet rolls and tubing products supplied by various defendants. Plaintiff claimed that he developed interstitial pulmonary fibrosis as a result of inhaling toxic fumes and dust from his work. He alleged that the metal supplier defendants concealed the dangerous nature of their metal products and sued them under negligence and strict liability theories. The metal defendants defeated plaintiff's complaint by filing various motions attacking the legal sufficiency of the allegations. The appellate court agreed that plaintiff's complaint had not stated a viable legal claim against the defendants. The court reasoned that the components part doctrine establishes that a seller of component parts may not be held liable for those products unless the component part is defective, the seller substantially integrates that component into the product design, rendering it defective, and the defect causes harm. The court also cited to the Artilio versus General Electric case, which held that component and raw material suppliers are not liable to consumers if the materials are not inherently dangerous, they are sold in bulk to a sophisticated buyer, and they are substantially changed during the manufacturing process. After considering both the components parts doctrine and the Artilio case, the appellate court determined that the metal defendants in this case owed no legal duty to the plaintiff. The court found that the raw materials here were not defective, and they were sold in bulk to the employer LaFell, who was a sophisticated buyer and who also substantially changed the metals to incorporate them into a final product. In the complaint, Maxton did not allege that he was harmed by the metals themselves. Rather, he claimed he was injured due to the manufacturing process over which his employer LaFell had complete control. So here it's important to note that liability was not imposed in part because the metals supplied were not defective. Now, liability could be imposed if, in fact, raw materials supplied were defective or were inherently dangerous, such as asbestos. The next case is a settlement case, and it's entitled Bowers versus Raymond Lucha Companies. In this case, plaintiffs filed a lawsuit against Raymond Lucha and others for defamation and related business torts. Lucha filed an arbitration petition. After the arbitration commenced, the parties agreed to settle their dispute before the arbitration panel had rendered its final decision. They agreed that through the settlement agreement that they would dismiss the state court litigation and then resolve their dispute by way of binding arbitration. If the mediation failed, the parties agreed that the mediator would issue a binding judgment in favor of plaintiffs from the range of $100,000, which represented the defendant's lowest offer, and $5 million, which represented the plaintiff's highest demand. The mediation did fail, and the mediator entered a judgment in favor of plaintiffs for their top demand of $5 million. Lucha objected, and plaintiffs petitioned to confirm their award. Lucha argued that the court could not confirm a binding mediation award as opposed to an arbitration award, and further argued that it was entitled to a full evidentiary arbitration after the failed mediation. Well, the trial court enforced the mediation award, relying on Code of Civil Procedure 664.6, which allows courts to enforce stipulated settlement agreements. The Court of Appeal affirmed. Here, there was substantial evidence to support express agreement to allow the mediator to enter a binding judgment. The court recognized that binding mediation was a valid form of alternative dispute resolution. The court rejected defendants' contention that it was entitled to an arbitration after the mediation failed. So it's important to note that courts will fully enforce stipulated settlement agreements in their terms. The courts will also fully enforce the parties' agreements to engage in alternative dispute resolution procedures, even if they're non-traditional, such as binding mediation.
All right, we have another settlement case. This is a pretty important case from the Supreme Court of California. Here, the plaintiff is an infant. He was born 37 weeks premature. At first, he resisted breastfeeding with his mother, and the next day had several bruises on his head, all of which was communicated to the pediatrician and the nurses. They decided that it was still fine to discharge the infant, and a couple days later, the parents noticed that the child's eyes were turning yellow and had chapped lips. And they, again, called to the hospital to let them know about these things, and they said this is normal. The yellow eyes was jaundice, and generally it's apparently pretty common in children and will go away after a few days. And they suggested to put some lotion on the child's lips and take him outside and get some sun. Well, the parents did that, and then a few days later, they noticed that the baby had become very lethargic. And so they called back in to the on-call doctor who heard all of these symptoms again and told them to get into the emergency room immediately. And when they did that, the baby or the infant underwent a blood transfusion. And excuse my pronunciation, but this was because a high amount of bilirubin had developed in his blood. But at this point, the blood transfusion couldn't help the development of kernicterus, which is a disorder that caused the infant severe brain damage. It's a very sad case. And then, of course, subsequently, the plaintiff sued both the hospital and the pediatrician. Prior to trial, the pediatrician and plaintiff came to a settlement. They settled for the term limits on the policy, which was $1 million. And at that point, they moved for good faith settlement pursuant to Section 877 and 877.6, which I'm sure many of you are familiar with, but for those who aren't, joint tortfeasors where one joint tortfeasor settles with the plaintiff, they can move for good faith settlement. If that's granted by the court, then the remaining joint tortfeasors are still liable for the remainder of any damages levied at trial minus a set-off and cannot go against the settling defendant. Well, however, in this case, the trial court found that the $1 million was grossly disproportionate to the pediatrician's potential liability. And so at that point, the plaintiffs and the pediatrician decided to continue a settlement. And the case proceeded to trial against the hospital, and the jury brought back a verdict of $15.5 million, mostly in economic damages, and allocated that 55% to the pediatrician, 40% to the hospital, and 5% to the parents. At that point, the hospital moved the trial court and claimed that the plaintiff was only entitled to $1 million, which was the amount of the settlement, and that is based on the California common law release rule. The common law release rule in California is a plaintiff that settles and releases one joint tortfeasor also releases all other joint tortfeasors. The exception is the statutory exception in 877 and 877.6, which once you get good faith settlement, you can now continue against the remaining joint tortfeasors. Well, the trial court, since there was no good faith settlement, was bound by precedent and had to apply that rule, holding that the plaintiff was only entitled to the $1 million that they settled with the pediatrician. After appeal to the appellate court again reluctantly applied the common law release rule under precedent, and again, the plaintiff appealed to the Supreme Court. I think the inequities are obvious here. The Supreme Court noted that in cases like this, it's often where one defendant only has so much to give, and that plaintiffs may need money in urgent in an urgent case such as this, and that is a reason for early settlement, and also evaluated the underpinnings of these types of torts, that the whole point of suing all of these joint tortfeasors is to make the plaintiff whole, and the common law release rule kind of severely undermines that ability. And so the Supreme Court abandoned the common law release rule in California and instead adopted a rule called set-off with contribution. What this enables the plaintiff to do is settle with one particular joint tortfeasor, set off that amount of settlement against the potential damages, continue against the remaining defendants, and at the end of the day, any amounts paid over the proportional share of liability of the non-settling joint tortfeasors, they can go back for contribution against the defendant who settled out. Now, the ramifications of this in these particular situations where good faith settlement is not possible are pretty extreme in my opinion. It really opens up plaintiffs to start settling individual joint tortfeasors at their will. And looking at it from the defense side, as you're seeing the walls crumble around you from other smaller, maybe bigger players who settle out for all of their funds and who often settle out for all of their limits and may not have much left. We've all been in cases where they're just tapped out. It's either a bankrupt entity or a bankrupt individual. There's really nothing else to get at the end of the day. It's really going to be the remaining joint tortfeasors and the remaining defendants in the case that really need to evaluate settlement as things start falling apart, and you may be a small player, but you're stuck with joint several liability. In this case, you could be on the hook for the whole thing and may or may not have the ability to effectively go back at the settling joint tortfeasor for contribution, because there may not be anything there to get.
The last case is involving work product privilege. It's Khoi versus the Superior Court of Stanislaus County. Now, this case has been around for a while, because the courts have gone back and forth, but good news, on June 25th of this year, the California Supreme Court unanimously clarified when witness statements and witness names are subject to work product privilege. In this case, the plaintiff, Deborah Khoi, filed a wrongful death complaint after her 13-year-old son drowned in the Tuolumne River in Modesto. The state of California sent investigators to talk to 6 juveniles who had witnessed the incident. The state's counsel provided the investigators with a list of questions. Each interview was recorded and later used by the state during the depositions of the witnesses. Plaintiffs served discovery to the state requesting disclosure of these recorded interviews and the identities of the witnesses. The state objected based on work product privilege. Plaintiffs filed a motion to compel. The state opposed the motion relying on the case Nat and Lewis versus Superior Court, holding that witness statements were entitled to absolute work product protection and that witness statements or identities were entitled to qualified work product protection. The trial court sided with the state and denied plaintiffs' motion to compel. The appellate court reversed. The Supreme Court granted review and held that a witness statement obtained through an attorney-directed interview is entitled to qualified work product protection. Absolute privilege might also apply depending on the facts. So the burden is on the party seeking disclosure to prove that denial of the disclosure will result in an unfair prejudice or injustice. The party resisting disclosure must make a preliminary foundational showing that the witness statement reflects the attorney's opinions, conclusions, or impressions. After this, the court must then conduct an in-camera review in order to determine whether the absolute work product privilege applies. Statements will be deemed protected if the witness statement is inextricably linked to the attorney's notes or comments that reveal strategy or tactical information. The Supreme Court further held that the identity of witnesses is not automatically entitled to any type of work product protection. Counsel asserting privilege must show that the witness's identity should be protected. And they can do that by showing that the revealing the identity of the witness would somehow reveal the attorney's tactics, impressions, or evaluation of the case. So this analysis set forth in Khoi indicates that attorney-directed interview statements are entitled to qualified work product protection. Absolute privilege might apply on a case-by-case basis after evaluation by the judge. Witness identities, on the other hand, are more likely to be discoverable because they are not automatically entitled to any type of attorney work product privilege. It may be difficult to establish that revealing the identity of a witness would somehow reveal attorney strategy, impressions, or evaluations. So this concludes our presentation, and thank you very much.
Thank you, and if you have any questions, just let us know.